Hi friends, this is Lokesh Pathak with you and welcome to the third class of Jurisprudence. So in the previous two classes we discussed about the definition of jurisprudence, its various interpretations by various jurists, and later we have seen in the second class the nature and the scope of the jurisprudence. And there we discussed that there are typically five types of schools. These are natural law school, analytical school, historical school of jurisprudence, sociological, and the last and not the least is American realism theory. And in the fifth one we will see with economic theory of law also. So now in this lecture we will start with the natural law school, which is the, if you see with regard to the volume of the study, uh, among all the schools natural law school is the biggest one, because here in the natural law school there are various stages. So in this we will discuss, first of all we will discuss what are the typical features of natural law school, what it said, and then we will see that there are the evolution of natural law school. It has five stages: the ancient stage, the medieval, renaissance, and the decline of natural law, and then in the last we will see about the revival of natural law school. We'll discuss about the various exponents or the philosophers who had been involved in various stages of natural law school. So to start with, what are the typical things, what is the basis of natural law school? See, natural law school takes reference from the divine law or law of morality. It's not a written law. It is independent of any convention of legislation. It takes from reference of religious principles, what the law of God is, what is the law of nature, what is a universal law, what is a divine law, what is the law as a result of morality of us. So it take reference from that. So its prime feature is that it is adaptable to meet the challenges, because it is not a written law or as per the statute. So it is adaptable. And in the transient society of today, if we try to inherit some of its features, this is its greatest attribute. It's, if you say natural law, it is inherent in the nature of the man, because universal law in all the communities, there is some basis to the morality and the natural law, which is the law governed by the God. As I said earlier, that this natural law is independent of conventions or legislation or any other instrumental devices. It's called the higher law or law of nature also. This law is unwritten law because it's not made by humans, unlike positive or man-made laws. This, in our Indian context, our Indian constitution also takes reference from some of the natural laws that we'll see in later stage when we'll discuss about the Indian constitution. Now what are the names of this natural law? Because it's being pronounced in various names, so you should know about various names. You should not be confused. So as I said, it is based on morality. So one name is moral law. It's also called divine law, law of nature, universal law, or law of God. So if anybody says any of these names, you should understand that he is trying to discuss about natural law school. So for natural law school, there is a jurist called Cohen. He said that it is a way of looking at things in a humanistic approach of judges and jurists. So he related it with humanity or humanistic aspects. It's seen that this natural law school, it's based on a priori method, means it accepts things on the basis of conclusion and not like posteriori or empirical method, which notice the things on the base of the inquiry or observation. So here in the natural law we discuss about the conclusion and we relate the things with the conclusion, and we never go to inquiry or observation like posteriori methods. So this natural law is divided into five stages. The first is the ancient. We'll discuss ancient first. So for the ancient natural law, when it was started, it started and developed by Greek philosophers in 4th century before Christ. So in 4th century BC, this natural law concept came. There are four important exponents in this ancient era, and those are Heraclitus, Socrates, Plato, and Aristotle. Heraclitus was the first Greek philosopher, and his period is from 530 BC to 470 BC. What Heraclitus did, he related or he said that natural law has three basic characteristics, and these are destiny, order, and reason. So he's the first person who related the natural law principle with the reason, that there is some reason given by God that derives the natural law. And he also related that with destiny, that whatever is in your fate it will come, and the order. While Socrates, who came after Heraclitus, Socrates' period was 470 to 399 BC, he said that like natural physical law, there is a natural moral law. So he gave the concept of natural moral law, and he said that justice is generally of two types, one is natural and one is legal. So he gave a proposition of legal justice also, but he kept on signifying the importance of natural justice. The next exponent is Plato. His period is 427 to 347 BC, and he was a disciple of Socrates. Now, Plato is the first person who gave a concept of ideal state, and that ideal state he named as a republic. So he gave certain features of that ideal state. He said that only intelligent and worthy person should be the king of the republic, and there should be a perfect division of labor in republic. So his approach is more towards idealism, and this approach was successfully accepted to some extent in the society also. The fourth and the last exponent in ancient era is Aristotle, and his period is from 384 to 322 before Christ. Aristotle has told that natural law is based on a reason which is unaffected by desires. So this was an appropriate justification. And on the other side, he says that man, who is a creation of God, articulates his actions. But there was a problem with Aristotle. He unfortunately justified slavery. He told that slavery is justified, and that was the point of huge criticism for him. So after these four in the ancient era, there was a place for a Roman system also. Because Roman people, what they did some considerable changes in the approach of natural law in the ancient period. They successfully transformed their rigid legal system to the cosmopolitan living law. And they divided the Roman law in three parts: jus civile, jus gentium, and jus naturale. Jus civile was meant for only Roman citizens, while jus gentium was applicable to Roman citizens as well as foreigners. Jus naturale was based on the above two, because it was the merging of these two, and it was extended to all, and hence this jus naturale was called as universal legal principle, because it was applicable to all. So this was all about ancient period, the typical exponents we discussed. Only problem here in ancient period was that in the late ancient period there was an increase in orthodoxy. People become orthodox. They try to relate everything with the religion, and they were lagging in analytical skills or the positive approach of law. So that was a disadvantage. Some of those points were reduced to some extent in medieval period. Medieval period, if you ask, it's typically from 12th century to mid of 14th century. And here in this period, there were certain changes which were made with respect to the ancient law period. These changes were that the natural law theory, it accepted the supremacy of law. The concept of state and law came, and it was considered that it is a gift of the people, agree to subdue them to their authority. So the concept of state was there. The increased orthodoxy of late ancient departed, which we just discussed, it departed in medieval period. But there was an origin of Catholic philosophers. So the church started to dominate in the medieval period, and there exists a confusion in correct interpretation of law. So based on these drawbacks, the period of Renaissance came. Renaissance period came from 15th to 18th century, and it was a breakthrough. It was a era of huge changes. Huge jurists with their different approaches and their different concepts came into this period. But what gave birth to Renaissance? Why it happened? Actually, in the modern classical era, from 15th to 18th century, the increase of rationalism or the origin of rationalism was there, which involved the emergence of new ideas and new ideas which denied the stereotype or the old traditional or ancient or medieval principles where we were blindly following the religious principles. So those were challenged because of the wave of rationalism. There was a wave of nationalism also, and there was a demand of absolute sovereignty of the state. There was a supremacy of positive law also, because when we go to the analytical school, we will see that this was a period that various analytical exponents came into picture and they started giving their theories. So the supremacy of positive law and the demand of absolute sovereignty, it also challenged the concept of the natural law. And the church, which was getting very strong in the medieval period, in Renaissance, because of the various revolutions, there was an overthrowing of the dominance of the church, and that was a major breakthrough in Renaissance period. Some of the exponents, some of them, they gave the introduction of the legal theory of social contract, which we will see when we will see about the exponents of in this period. And sovereign elected and empowered to safeguard citizens the social contract that we'll see. So there are five exponents in this period, and these are: the first one is Hugo Gracias, the second is Thomas Hobbes, third is John Locke, fourth is Jean-Jacques Rousseau. Rousseau is very famous in history also, so you might have heard about him somewhere. And the last one is Immanuel Kant. So we'll start with the first, which is Hugo Gracias. His period is 1583 to 1645 AD. He's the one who gave the theory of functional natural law in his famous book Law of War and Peace in year 1625. He is also the founder of modern international law. He said that however bad a ruler may be, but it is a duty of subjects to obey him. Also, he said that natural law is not merely based on region, but on the right region. But the problem what he said is he contradicted at some places. As he said that no one should be should deny what the ruler has said, but at the same time he said that ruler is bound by the natural law. So in this way he's saying that nobody can deny the natural law. So these things were challenged, and the next exponent came in picture was Thomas Hobbes from year 1588 to 1679. Thomas Hobbes has given a very famous saying that natural law, life, is short, brutal, and solitary. And later this saying was challenged by Rousseau. Hobbes is the person who gave the social contract theory, which is a very important theory, and this question is very important in your exams, that who gave the theory of social contract and what it is. So if it comes, you have to say that Thomas Hobbes gave the theory of social contract, and it is in relation to evolution of a state, supported absolute power and authority of a ruler. So this theory says it supports the power and authority of a ruler, but that should be supported by the authority of state. At the same time, he completely denounced the religious and metaphysical character of natural law. In his social contract theory, he said that man voluntarily entered into contract and surround his freedom to some mightiest authority to protect his life and liberty. So this way he justified that there must be a mightiest authority like king, which protects the life and property of the people. And for that king, the people voluntarily or knowingly enter into a contract that they surround their freedom to that mightiest authority, and in return that mightiest authority give them the protection from life and liberty. So this concept was later improvised by John Locke, who's the next exponent in this period. John Locke period is from 1630 to 1704 AD, and he rejected Hobbes' idea. He refined it. He said that it is wrong to say what Hobbes has said, that people give their all the authority or freedom to a mightiest authority to protect life and property. It's not so, because he said that the natural rights, which are comprising of life, liberty and property, it retained with man. Man can never surrender these three rights to anybody. And these three rights are natural rights, and these are life, liberty and property. So these remain with the man, and state and law is only limited to maintaining the social order and enforcing the laws. So this way, while Hobbes supported the state authority, Locke pleaded for individual liberty, and he emphasized on the natural rights, that these natural rights should remain with the person itself. The next exponent is Jean-Jacques Rousseau, which is the most important exponent in the period of Renaissance. His period is 1712 to 1778 AD. He immediately discarded the concept of social contract given by Thomas Hobbes. He told that it is a hypothetical concept. Rousseau challenged Hobbes' thought of saying natural life is as short, brutal and solitary. And further, he introduced the concept of general will, which is called volonté générale. So the concept of general will was given by Jean-Jacques Rousseau. The general will says that individual parts with their natural rights. You see the difference. Hobbes was told that people depart from their rights to get life and liberty, while John Locke said that natural rights like life, liberty and property remains with man. Now Mr. Rousseau says that the natural rights which were defined by John Locke, he said that these natural rights, people depart from his natural right, and in return they get civil liberties such as freedom of speech, equality, assembly, etc. So this way the person hand over the power to a community, and it is a duty of each person to obey general will. So he related the general will concept with the natural rights and not all the rights, and he gave the importance to a community. And he further said that it is a duty of each person to obey general will. So this way we can see that while John Locke, he emphasized on individualism, Rousseau emphasized on people's sovereignty. Now the last exponent, or the fifth exponent in Renaissance period, is Immanuel Kant, and the period for Immanuel Kant was 1724 to 1804. So Immanuel Kant, he told that the basis of social contract is reason and not historical fact. So he related the social contract concept with the reason. He told that rights are of two types. One is natural rights and another is acquired rights. And it is only the natural rights which are necessary for the freedom of the individuals. He gave a theory of categorical imperative, which is a classic work entitled Critique of Pure Reason. So in his classic work of Critique of Pure Reason, he gave a theory of categorical imperative, and this theory was derived from Rousseau's theory of general will. He also gave a doctrine of autonomy of will, in that he said that the action emanating for a reason. So this was all about the period of Renaissance. Now the next period is the decline of natural law, and this happened in the 19th century because of the rise of positivism, which we will take up in the analytical school. And there were certain other factors also. The other important factors are doctrine of laissez-faire. So laissez-faire was a concept which took birth in 19th century, and it related with the minimum interference of a state in economical matters, but this economical concept was extended to the legal concept, and which weakened the concept of sovereign. At the same time, there was a empirical theory which was proposed by Montesquieu, who belongs to historical school and sociological school also. So we'll take up that later. But it's worth to mention here that Montesquieu's theory, empirical theory, it challenged the concept of natural law. In a quick way, I would like to tell about this theory, what it is. In this theory, Montesquieu has told that laws are the creations of climate, social, topography, environment, customs and commerce. And also he added that natural law is vague and confusing. So he gave this concept, he gave the theory of empirical basis for determining the law, and at the same time he challenged the natural law. This theory had been very important in closing the ventures of natural law. And there were the birth of other jurists also, like Bentham has came in the picture and Austin has came in the picture from analytical school. Auguste Comte, he was there, yeah, from the sociological side, because he was a very famous sociologist, and he told that natural law theory is false, non-scientific, and it is based on the supernatural beliefs. While Bentham and Austin, they told that natural law is absurd, confusing, and just a nonsense. So, with the huge criticism from these renowned jurists, and in parallel, the acceptance of the theories given by those jurists, these all factors had been very bad to natural law theory. And this period in 19th century, because of all these factors, there was a decline in natural law theory. But in 20th century, the fifth stage came, and which was the revival of the natural law theory. And for the revival, we should remember two important exponents. The one is Rudolf Stammler, and the other one is a Joseph Kohler. So, as an overall, before we go to the exponents, the revival of the natural law, it was based on the premise that we should follow the value-oriented ideology, and just we should not blindly follow what is being followed since traditions and since years. So the first exponent, Mr. Rudolf Stammler, his period was 1856 to 1938, and he gave the two fundamental principles of law. He said that law is important when there is a principle of respect and there is a principle of community participation. So he related the law with these two principles, which are respect and community participation. He also said that law is a law of nature with a variable content. So it should be there with a variable content, it should not be fixed, and it should not be blindly followed. The second exponent is Joseph Kohler. His period is 1839 to 1919. And Joseph Kohler has simply said that there is nothing called eternal law. Means law has to be changed. We cannot just follow something just because it is being followed since years. And he said, he gave a very beautiful and acceptable statement about the origination and development of law. He said that the law shapes itself as the society advances morally and culturally in the course of its evolution. So this way he gave a concept of change to the law as per the development and advancement of society in terms of morality and cultural. So this is all about the natural law school. I hope you might have understood. This is the biggest school if you see. So I try to wind it up in a very short time. So there are exponents, and the portion of Renaissance is very, very important. Also, the portion of 20th century revival is important. So these two needs to be concentrated a lot. Before I wind up, I would like to take a small question which may come from the natural law school, and that is how the natural law principles are taken in Indian Constitution. So if this comes, there are very small points. I would like to just say you the points which you should keep in the mind, which can be developed and written in the exams if it comes. So the natural law principles in our Indian Constitution, there are 9, but typically they can be divided into 2 parts. The first part is natural justice, doctrine against bias, judicial review, which is provided in Indian Constitution, reasoned decisions, and precepts of administrative law. So these are the 5 key points which determines the presence of natural law principles in Indian Constitution. I would like to repeat these 5 again: natural justice, doctrine against bias, judicial review, reasoned decisions, and precepts of administrative law. While there are other 4 principles which are borrowed from English doctrine of equity, justice, and good conscience. And these 4 principles are law of trust, specific relief, doctrine of election, and rules against perpetuity. So you should keep all these points in mind. There might be very short questions based on this, that what are the natural principles in Indian Constitution. So with this, I would like to close the natural law school. I hope it will help you in understanding the natural law school. In the next lecture, I would like to take up the analytical school and its exponents. Thanks for being with me. Thank you.